Hi, my name is Alan Weiss from AussieDivorce.com.au. This video provides you basic information only, and it is not a substitute for a professional or legal advice. It is prudent that you obtain a legal advice from a family lawyer when contemplating a separation or divorce, or soon after a relationship comes to an end. In this video, I'm discussing a family law matter that involves a prenuptial agreement. The issue before the court was whether a prenuptial agreement made between a husband and wife constitutes a binding financial agreement that satisfies the requirements of the Family Law Act. The agreement provided that the house purchased by the husband would be used as a family residence during the marriage, but would become the sole property of the husband in the event of a divorce. The wife did not earn any income, but was responsible for the care and upbringing of the 3 children, the housemaker. The agreement did not provide for payment for maintenance to the wife in the event of a divorce and did not compensate her for the financial sacrifice she has made. Those sacrifices allowed the husband to work and improve his earning ability, his financial situation. The case draws an important distinction between a prenuptial agreement that bind the parties and financial agreements that bind the court. An agreement that specifies how the husband and wife will handle their finances during their marriage or relationship can be enforced like any other contract. An agreement that requires a court to divide in a property in a specified way in the event of a divorce, however, will not override the court's general authority to make a fair property settlement unless it meets the test of a binding financial agreement. The wife argued that whether or not a prenuptial satisfied the requirement of a binding financial agreement, it was not an agreement at all, because she was induced to sign it by the husband's claim that he would not otherwise buy the family home. In fact, he already entered into a contract to purchase the house and was not in a position to back out of it. The husband's misrepresentation and the true intention was to force his wife to sign the prenuptial agreement. The court decided the agreement was induced by misrepresentation and was therefore not binding on the parties. A financial agreement is binding on the court only if both parties received an independent legal advice concerning the effect of the agreement. The wife's lawyer incorrectly advised her that the prenuptial agreement can never bind the court. The court decided that the legal advice does not mean a correct legal advice. The wife's remedy for the incorrect advice she received from her lawyer is a lawsuit against the lawyer for negligence. In this case, however, since the agreement was not binding on the parties, it was not binding on the court. That made it possible for the court to divide the property and award maintenance in a way it deemed fair, notwithstanding the provisions of the prenuptial agreement. It is important for you to receive an independent legal advice, preferably from a family practitioner. There are a lot of people out there who will provide you a cheap way out to secure your future. But when it comes to the test, you're holding on the risks of not knowing how the court will behave. Again, if you are entering into a financial agreement, do it properly. Interview a number of lawyers, do your research, discuss it with your partner. Each of you will have to have an independent legal advice, but do it properly. To read the full article, click the link below.